Okay, good morning everyone. I'd like to begin by just thanking DePaul and Brett Davinger and Josh Sharnoff and Bobby Quall and the entire staff here and all the other members of the Ipsc consortium. This kind of stuff takes a lot of work to put on. It's work that we don't see, especially if it's well done. And it is well done, and so we don't see it, but I appreciate all the work that's been done to put together this program. So I want to talk today about a project that Dotan Oliar and I are involved in. And this is sort of a project in progress report that I want to provide rather than a work in progress. I don't have one thesis that I'm going to defend here, but we're involved in constructing and releasing a data set initially of original valid monograph registrations. I'll talk about what that means. And then possibly additional data sets that are based on the Electronic Copyright Office catalog. So I'm going to talk about what that is, what is the Electronic Copyright Catalog and what its contents are, what data is available about original monograph registrations, limitations and pitfalls of that data, some potential interesting inquiries, and some tentative analyses we've done in part to pursue those inquiries, but in part simply to test our construction of the data set and see where we may be doing things wrong. So what's the Electronic Copyright Catalog? It contains records of various kinds of registrations and documents from 1978 to the present. The version of the catalog we're working with right now was a complete download as of September 30th, 2014. I'm not sure what that's doing. What is going on here? I'm going backwards. That's what's going on. Let's try this rather than the clicker. Okay. The Copyright Office catalog contains about 27 million records as of that point. I sort of had to figure out, so how do you tell one record from the other? Each record is self-contained. They're not set up in tables. Each record is a just separate little electronic packet. But you can see here there are about 17 million copyright registrations, of which 16 are for monographs and 1 million are for serials. There's about 8.7 million relating to recorded documents, a small number of copyright pre-registrations, about 1 million for deposits under Section 407, about 20,000 masterwork registrations, and then there's some miscellaneous test records and other things in there. What about the monograph copyright registrations? Well, we focused on monograph registrations initially because serial registrations tend to have not too much information about the works that are being registered, right? The author and claimant of the serial is typically the company that's producing the magazine, which doesn't tell us anything about who actually wrote the articles in the magazine, stuff like that. So, of original registrations, we figured out, of monograph registrations, we figured out that there are actually 3 types of registrations respecting monographs. There are original registrations, so registrations for new works created or registered on or after 1978. Supplementary registrations for correcting something in the original registration. And then renewals for 1909 Act works, but that are being renewed through 1992. And then of each of those, right, there are valid registrations that remain in the catalog as valid registrations. Then there are registrations that have been canceled. The records are still there. They're just marked canceled. And so we are now focusing on these initially. Original registrations, so first registrations for new works that haven't been registered before, that are valid, that haven't been canceled. That's the data set we're working on producing. What kinds of information are available as with respect to those works registered across the entire span of 35 years, 1978 to the present? We're actually working through 2012. So here's principal types of information. So we got some dates, the date of registration, the date or the year that the work was created, the year of publication, or the status of the work as unpublished, names of claimants. Those aren't standardized, so there could be variations in the name of a claimant. A claimant could be International Business Machines in one record and IBM in another, for example. The number of claimants per work, whether that claimant is an individual or a business entity, and then business pseudonyms, right? Companies that are doing business as another name. For authors, we have their names, but again, not standardized. The number of authors per work, whether they're individuals or business entities. Their birth and death years. For about half of the authors, we have at least the birth information. Most of them haven't died at the time of registration, and so they're just marked as still alive. And then their pseudonyms, right? If they're using a pseudonym, what the pseudonym is. And then lastly, we have information about the type of work it is. Now, what's the classification scheme for type of work that is in the catalog? It's a little different than the 8 types that we're used to in seeing in section 102. This scheme was actually based on the registration classes of 1909. The examiners decided that they wanted to still have some more specific information about type of work, so they kept these codes in there, even though they were cutting down on the number of different types of registration applications. So here are the classes: non-dramatic literary work, like text, dramatic work and choreography, musical work, cartographic work, artwork, multimedia kit, motion picture, sound recording, combined sound recording and text, combined sound recording and music, and computer program. So that's what we have to work with. Some limitations and pitfalls of this data. So I think it can be said, having worked with this data for a long time now, that the implicit goal of this catalog is to provide copyright information to a human reader who has some familiarity with copyright and who's reading the entire record of a copyright registration, right? What kinds of problems does that have? It means that there can be lots of inconsistencies in the data from a machine-readable standpoint that humans can kind of get over. So you can use different fields to store data. You could change from using one field to another. As long as it all shows up in the resulting record, you're not too worried about that. You could mix different types of data in a single field. You could have the title of the work and the author in a single field. You can combine instances of data. So sometimes you could have 2 different instances of a field for 2 different authors, and sometimes you could put the 2 names of the 2 authors in a single field. You can separate out the combined instances differently, right? So sometimes you could have an ampersand that separates out 2 authors' names. Sometimes it could be a comma, a semicolon, stuff like that. You could use inconsistent terminology. You could say, as employer for hire, for work made for hire, or you could say work made for hire. Inconsistent formatting. You could format dates as April 16th, comma, 1972, 16 April 1972, etc. And you can rely on contextual interpretation. So you could have one field that says such and such a work, right? A novel by Vladimir Nabokov, translated by whoever, right? And then a different field could say, claim limited to translation. And by that, you have to understand that the only author of the work that's being claimed is the translator, not Nabokov, right? So, problems, right? At some points I've thought, given these problems, this is just an impossible task. On the other hand, when we've done analyses, we find out that with a lot of respect to a lot of these problems, they're relatively small in nature in terms of the percentage of the records affected. So It's not true that the Copyright Office doesn't have cataloging standards. They do. But they haven't had sort of electronic validation. And so if a new cataloger makes a mistake, that just goes straight into the catalog, right? So what are some interesting inquiries we could pursue with this data? Here's some possibilities, right? Think about, has disintermediation taken place? Has the internet resulted in more authors continuing to hold copyright and connecting more directly with audiences rather than going through publishers or other intermediaries and having them hold copyright? Are fewer or more works being produced as works for hire, right? Are we having industries in which there's employment or are there independent contractors? Is co-authorship with regard to various types of work on the rise or decline? Is collaboration going up or down? Who registers the most works, right? The most frequent registrants. Author ages. At what average ages do authors produce different types of work? Has that changed over time? Author genders. If we match first names against gender probability lists, what can we find about the genders of authors across work types and times? Pseudonym use, right? How have authors of different types of works used pseudonyms? I already covered most frequent registrants. And then assessing certain kinds of incentives. For example, you recall that the 76 Act has this incentive to publish previously unpublished works. It grants them a guaranteed term of copyright. How often has that been used? So let's take a look at some actual tentative analyses and see how some of this stuff works out. So here's a chart of the percentage of individual claimants by type of work running across a 35-year period. And of course, the obverse of this would be corporate claimants. So if you've got a line down here at 0.1, you're seeing that 90% of the motion pictures are claimed by companies rather than individuals, and that stays pretty constant over the entire 35-year period. You're seeing that for dramatic works and for sound recordings and musical works, somewhere between 80 and 90%, or 85 and 90% of those works are being registered by individuals. And then you see the other types of works spread out. So immediately you get a sense that, wow, as between types of works, you've got a wide spread of whether individuals or corporations are the claimants. You see some variation over time, like computer programs has this seemingly constant dip until the end. Sound recordings has a weird bubble there in 2006 to 2008. And I'm familiar with the fact that also the number of sound recording registration goes way up in those years. So there must be something going on there where somebody is registering a lot of sound recordings. Break this down to the distinction between published and unpublished works. So if we considered published as a proxy for more commercially successful works, right, we see, okay, so more of those are being registered by corporate claimants than individual claimants. The big downward shift among all categories. On the other hand, we do see, I think, some upward trends in most of those categories, again, except for computer programs. You're seeing slight upward trends towards individual claimants in most of those categories. Is that a case for disintermediation happening? I don't know, but it's at least beginnings of a story to investigate. Unpublished works, if we took the unpublished works out, right, big bounce toward individuals. There's a lot more individuals who are registering unpublished works in all categories, and those are perhaps less likely to be commercially successful. There's also less of a trend. It turns out that more individuals, except for artworks, right? Artwork seems to be going down. And here you just mix them all together for 1 year, 2012, to get a sense of the percentage of individual claimants with regard to all works, to published works, and to unpublished works. And I'm not sure what to say about that, except that with regard to some kinds of works, there's not too much difference between unpublished and published works. With a category like musical works, there's a very large difference. You see many more corporate claimants with regard to the published works. Average age of authorship by year of creation. So this is really interesting, and I'm not sure what to do with it. And I'm also, I have to say, a little worried that it represents some kind of artifact that I haven't discovered yet. But this is for hundreds of thousands of authors per year, so it's not a sampling issue. And we see a pretty consistent trend upwards in age. So in 1978, the average age of the author of a musical work is about 33. By 2012, it's about 38. And you can see the rest of those climbing upwards as well. Obviously, again, a substantial difference between types of works. The average age of authors of text or of non-dramatic literary works is almost, 10 years older than the average age of an author of a musical work, and then the others are in between those two. This is the standard deviations for those works. We can see those climbing at the same time that the ages are climbing. So the average age is climbing, but at the same time it's spreading out more over the last 35 years as well. And I don't know what to make of it. This is one measure of sort of collaboration, or in this case, the lack of it. So what percentage of works registered are registered with a single author as opposed to any more than one author? And you can see great breakout between different kinds of works. There's something strange here going on with these two categories, right? With motion pictures and with sound recordings. That they have such a huge difference between beginning and end. I'm a little worried that that has to do with some cataloging change in practice that we're not sure what it is yet. It may be, for example, that in the earlier catalogs, the director of a motion picture is being included as an author, as well as the company that is producing the work as a work made for hire. And so you're seeing a lot of that in the earlier years, and then that practice stops or is modified. But we've got to go look at hundreds and hundreds of thousands of registrations to figure out whether that would be the case. Same kind of figure for published works. And we see more variation, so there's more collaboration going on in published works than in all works as a whole, and lots of spread between different kinds of works, right? Artworks are still among the least likely to be co-authored, and whereas musical works, published musical works, are much more likely to be co-authored. How about uses of pseudonyms? All right, so notice these are very small numbers. We're talking about 1% here at the last to top line. But they're different between different types of works. Huge bumps towards the end. I'm worried that that has to do with the adoption of electronic cataloging system or application system in which applicants can enter their own information, that they're entering more pseudonyms when they do it themselves on the internet. But take it for what it's worth. And then here's just a sample of the top 15 copyright claimants in 2 years, 2010 and 2012. Interesting to see the companies here, the kinds of industries represented. Some of the names are very familiar and are kind of consumer brands. Some of them aren't. Some of them, Dream Room Productions is a pornography distributor, as is Bang Brothers. So you've got those up in the top 15. You've also got textile companies doing a lot of registrations. Savoy Holdings and Star Fabrics are both textile companies. So there we go. I've got 2 minutes left, but I appreciate any comments or thoughts you might have. Yeah, Mike.
So this is just fascinating stuff, but the thing that leaps out at me, particularly just when you frame it with the initial character of the data set, is how sort of the methods of cataloging the data to begin with are sort of informed by and inform certain things. So this is a library cataloging system that is generating library cataloging data. It is not a system of, say, commercial law or a system of, sort of title registry as you would have in a property rights system. In other words, it's not a system that is designed from the outset to give certain kinds of notice to third parties about various aspects of claimants, content of the work, duration of rights, all those sorts of things, which if you were designing a commercial law system for third-party claims in assets, as in a secure lending scenario, this is not that kind of a catalog. This is not a land registry parallel where you're designing.
It isn't. I mean, I actually think that the Copyright Office sort of does think of it as providing notice. They think of it as providing a tool for people who want to search the status, copyright status of a work. But you're right that it's kind of hybrid in that respect. And if you were designing a full-on notice system, it would be more rigorous in certain ways than it actually is.
So a quick follow-up. So the one question that occurs to me is, so you've described the kinds of questions that you're able to get some initial answers to based on the data that you have available, but I would be interested to think about what kinds of questions you would like to ask but that you're not able to answer because of the character of the catalog.
That's time.
Okay, well, I appreciate that. I'm sorry that the time is up, but I appreciate any more comments you might have during the break or otherwise. Thanks.